Your decision regarding the appropriate sentence should be based upon proven aggravating factors and established mitigating circumstances that have been presented to you during these proceedings. The next step in the process is for each of you to determine whether the aggravating factor or factors that you have unanimously found to exist outweigh or outweighs the mitigating circumstance or circumstances that you have individually found to exist. The process of weighing aggravating factors and mitigating circumstances is not a mathematical or mechanical process. In other words, you should not merely total the number of aggravating factors and compare it to the number of total mitigating circumstances. The law contemplates that different factors or circumstances may be given different weight or values by different jurors. Therefore, in your decision-making process, each individual juror must decide what weight is to be given to a particular factor or circumstance. Regardless of the result of each juror's individual weighing process, even if you find that the sufficient aggravators outweigh the mitigators, the law neither compels nor requires you to determine that the defendant should be sentenced to death. Once each juror has weighed the proven factors, he or she must determine the appropriate punishment for the defendant. The jury's decision regarding the appropriate sentence must be unanimous if death is to be imposed. To repeat what I have said, if your verdict is that the defendant should be sentenced to death, your finding that each aggravating factor exists must be unanimous. Your finding that the aggravating factor or factors are sufficient to impose death must be unanimous. And your finding that the aggravating factor or factors found to exist outweigh the established mitigating circumstance must be unanimous. And finally, your decision to impose a death sentence must be unanimous. This process is spelled out in the form of questions, and when you finish question 1, you move on to question 2, so that it makes it a lot easier to understand the process of what do we do next. You will be provided with 17 forms. It's actually, each count includes a different victim, as you all know. And each verdict form for each count and or each victim is 4 pages. And you must fill out all 4 pages because, like I said, there are specific questions about the aggravators and the mitigators and the weighing process that you have to answer along the way. And there are also instructions on the verdict form that will show you when you need to move on to the next question or when you're finished. Again, you will be provided with 17 verdict forms to reflect your findings and a decision regarding the appropriate sentence for each count of first-degree murder. If your vote on the appropriate sentence is less than unanimous, the defendant will be sentenced to life in prison without the possibility of parole. The fact that the jury can make its decision on a single ballot should not influence you to act hastily or without due regard to the gravity of these proceedings. Before you vote, you should carefully consider and weigh the evidence, realizing that a human life is at stake, and bring your best judgment to bear in reaching your verdict. Weighing the evidence. When considering aggravating factors and mitigating circumstances, it is up to you to decide which evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in making your decision as to what sentence should be imposed. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are, did the witness seem to have the opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Did the witness's testimony agree with other testimony and other evidence in the case? Had the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? Had any pressure or threat been used against the witness that affected the truth of the witness's testimony? Did the witness at some other time make a statement that is inconsistent with the testimony that he or she gave in court? Had the witness been convicted of a felony or a misdemeanor involving dishonesty or false statement? The fact that a witness is employed in law enforcement does not mean that their testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give an opinion. However, an expert's opinion is only reliable when given on a subject about which you believe the person to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. This witness should not be discredited by talking to a lawyer about their testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not be influenced in any way by his decision. No juror should ever be concerned that the defendant did not take the witness stand or give testimony in the case. These are some general rules that apply to your discussions. You must follow these rules in order to make a lawful decision. You must follow the law as it is set out in these instructions. If you fail to follow the law, your decision will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. Your decisions must be based only upon the evidence that you have heard from the testimony of the witnesses, have seen in the form of exhibits and evidence, and these instructions. Your decision must not be based upon the fact that you feel sorry for anyone or that you are angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision. Your decision should not be influenced by feelings of prejudice or racial or ethnic bias. Your decisions must be based on the evidence and the law contained within these instructions. In just a few moments, you will be taken to the jury room by the court deputy. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. When you have reached decisions in conformity with these instructions, the appropriate forms should be signed and dated by your foreperson. Your decision must be in writing, and for your convenience, the necessary verdict forms have been prepared for you, and they are as follows. Now, I don't want to downplay the fact that there are 17 counts. It's just that there's 4 pages of forms for each of the 17 counts. But you have to carefully consider and evaluate each count as if you were only here to consider one count. In other words, you need to give the same time and attention to each count, each of the 17 counts. With that being said, I don't think it's necessary for me to read the verdict form for every count because as far as the students are concerned, remember there are 5 aggravating factors that are alleged for the students. So the students have one verdict form, and then the employees have another verdict form. So I'm going to go over one of the students' forms and one of the teacher's forms so that you can see that there is a difference. But I'm not going to go over all of them because after I go over the first one, I think they'll be self-explanatory. So for example, it starts off, the state of Florida versus Nikolas Jacob Cruz, jury verdict form as to count 1, victim Luke Hoyer. Aggravating factors as to count 1, victim Luke Hoyer. The first question you have to answer is, we the jury unanimously find that the state has established beyond a reasonable doubt the existence of an aggravating factor. Nikolas Cruz was previously convicted of another capital felony or of a felony involving the use or threat of violence to another person. And then you check yes or no. After you answer that question, no matter what your answer is, you move to question 2. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of an aggravating factor. Nikolas Cruz knowingly created a great risk of death to many persons. You answer yes or no. Regardless of your answer, you move to question 3. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. The first-degree murder of Luke Hoyer was committed while Nikolas Cruz was engaged in the commission of a burglary. You check yes or no, and then you move to question 4. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. The first-degree murder of Luke Hoyer was especially heinous, atrocious, or cruel. And you answer that yes or no, and you move to question 5. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. The first-degree murder of Luke Hoyer was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification, and you check yes or no. Then you follow the instructions in bold, and it says, if you answer yes to at least one of the aggravating factors listed, so that's the 1 through 5, if you answer yes to any of those, please proceed to section B. If you answered no to every aggravating factor listed, do not proceed to section B. If you answer no to every aggravated factor, Nikolas Cruz is not eligible for the death sentence and will be sentenced to life in prison without the possibility of parole. If you answered no to every aggravating factor listed, please sign and date the verdict form, which is on page 4. So in other words, if you answer no to questions 1 through 5, you do not have to answer the remaining questions. You just sign and date the verdict form and indicate that you've reached a verdict. However, if you answer yes to at least one of the aggravating factors, you go on to section B, which starts on page 3. And it says, sufficiency of the aggravating factors as to count 1, Luke Hoyer. Reviewing the aggravating factors that we unanimously found to have been established beyond a reasonable doubt, we, the jury, unanimously find that the aggravating factors are sufficient to warrant a possible sentence of death. And then you check yes or no. If you answer yes, you go on to section C. If you answer no, don't go on to section C. Simply sign and date the verdict form and indicate that a verdict has been rendered. If you do answer yes, you go on to C, mitigating circumstances. One or more individual jurors find that one or more mitigating circumstances was established by the greater weight of the evidence? Yes or no? And then you can see in the next section, it gives you instructions. Please proceed to section D regardless of your findings in C. So it's important after each section to read the next instructions to find out, do I go on or, do I not? D, eligibility for death penalty for count 1, Luke Hoyer. We, the jury, unanimously find that the aggravating factors that were proven beyond a reasonable doubt outweigh the mitigating circumstances established as to count 1. And you check yes or no. You go to the last page of, it says Hoyer at the top of each page, so you'll know which verdict forms go together in case they get mixed up. And it says on the top of page 4, if you answered yes to section D, please proceed to section E. If you answered no to section D, you do not proceed. Nikolas Cruz will be sentenced to life in prison without the possibility of parole. Please sign and date the verdict form. If you answered yes to section D, you move on to section E. And this is the last question. Having unanimously found that at least one aggravating factor has been established beyond a reasonable doubt, that the aggravating factor or factors are sufficient to warrant a sentence of death, and the aggravating factor or factors outweigh the mitigating circumstances, we, the jury, unanimously find that Nikolas Cruz should be sentenced to death. And then you check yes or no. Then the foreperson will sign and date the verdict form. So that is the example of the verdict form that I just went over with you that applies to what I'm going to refer to as the student victims. Okay? There's 14 of them that are identical as far as the form is concerned. Now, obviously they're not identical people, and again, they should be considered separately and apart. The 3 adults have a different verdict form, and I'm going to go over the verdict form for Christopher Hickson to give you an example of what the verdict form for Christopher Hickson, Aaron Feist, and Scott Beagles look like. It starts off exactly the same. It has the name and the jury verdict form as to count 9. It indicates that it applies to Christopher Hickson. You'll see under aggravating factors, section A, the first 5 questions are the same. The only difference is that there are 2 additional aggravating factors that are alleged for the adults, and they are as follows. They're in questions 6 and 7. We, the jury, unanimously find that the state established beyond a reasonable doubt the existence of the aggravating factor. The first-degree murder of Christopher Hickson was committed to disrupt or hinder the lawful exercise of any governmental function or the enforcement of laws. Check yes or no. The adults also have number 7. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. Christopher Hickson was an appointed public official engaged in the performance of his official duties if the motive for the first-degree murder was related in whole or in part to Christopher Hickson's official capacity. The rest of the form is the same. So that's the only difference, that there are 2 additional aggravating factors for the adults. The adult victims, again, Christopher Hickson, Scott Beagle, and Aaron Feist. It's set out very clearly in the instructions, but in case you're wondering what the difference is, it's the adults have a 5-page verdict form as opposed to a 4 because of those 2 additional questions. Otherwise, they are identical.